So another federal court ruled that the federal laws restricting machine gun possessions are in fact a violation of the Second Amendment. But AG Bondi and the Trump administration continue to make anti-gun arguments in this critical Second Amendment challenge. So let's break down what just happened in this critical case. Now, before we jump into this video, I want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to protecting yourself after a self-defense incident, AOR is in a league of their own. AOR is backed by an actual law firm, Attorneys for Freedom, so they can help you in self-defense incidents and situations that maybe other companies would not. And one of the really cool things about AOR is they're always expanding their coverage, they're expanding their benefits. Recently, they expanded to include things like civil liability coverage, red flag laws, expungement, and they're also going to be adding a lot of new things as well this year. So if you're interested, I highly recommend that you check out AOR using the links down below in the details section, also in the pinned comment. And also, if you use my code ARMEDSCHOLAR, you can get $50 off of your individual sign-up plan or $25 off of the family plan. So again, check them out using the links down below. As I mentioned in the intro, in this video, we're going to be talking about a critical Second Amendment machine gun challenge that's currently in front of the Fifth Circuit Court of Appeals. In this US versus Brown case, the Trump administration still appears to be making anti-gun Second Amendment arguments in this case, and they're pushing for the Fifth Circuit to avoid review of this case. Recently, the United States government filed a brief to the Fifth Circuit, and they continue to argue that machine guns are not protected arms under the Second Amendment, and that the lower court's decision should actually be reversed. And recently, they also filed a supplemental notice to the Fifth Circuit, pointing to another win that they recently got and received out of the 10th Circuit Court of Appeals, and that case also involved machine gun possession bans. That additional case is called US versus Morgan, and the Morgan case was the first district court decision striking down machine gun possession bans. The Brown decision here relied heavily on that prior ruling in the Morgan case, and now the Trump DOJ is leveraging their win in the 10th Circuit to influence this upcoming Fifth Circuit ruling and the potential oral arguments, and they're also trying to use it to avoid the Fifth Circuit even hearing arguments in this case. Now, in this Brown challenge that we're talking about here in the Fifth Circuit, the lower court judge originally stated that Section 922(o) makes it illegal to possess a machine gun unless the machine gun was lawfully possessed before the date of this subsection even takes effect. As Judge Brooms explained in US versus Morgan, the statute criminalizes the mere possession of such weapons without regard to how the possessor uses them. He then states that if an individual purchases such a weapon and locks it away in a gun safe in his basement for 20 years without ever touching it, he is as guilty of a violation of 922(o) as someone who takes the same weapon out into public and takes it into the streets and displays it in an aggressive manner. He went on to state that every appellate court's prior precedent was rendered obsolete. Under the new standard established by Bruin, the government must prove that its desired firearms restrictions, which here means the statute criminalizing simple machine gun possession, is consistent with the nation's historical tradition of firearms regulations. This is a heavy burden, he stated. The historical justifications that the federal government here in this case presented for the whole machine gun possession charges and prosecution of Mr. Brown included things like the Statute of Northampton relating to the riding and going armed offensively to the fear and terror of good citizens, but the judge here rejected that as not valid historical support for Mr. Brown's conviction. And the judge also pointed out that the record shows there are more than 740,000 machine guns that are lawfully possessed within the United States as of 2021. He states that 740,000 is no small number, and that the government presents no argument or explanation how such a large number of firearms is not some ways, in common use for lawful purposes. Now, to contest the number of machine guns presented in this case and the whole argument of common use, the federal government here, the Trump administration, relied only on a Fifth Circuit prior case called Hollis. However, that case is now invalid because of Bruin, and the number of machine guns presented in that prior case, Hollis, was only accounting for about 175,000 machine guns. However, now under Bruin, in the clear counting of at least 740,000 machine guns, the argument here is that Hollis does not stand as binding precedent, and it now is essentially overridden by what happened in Bruin. Now, based on that, the judge here agreed with Mr. Brown's as-applied challenge and granted his motion to dismiss the case based on the Second Amendment. Now, the U.S. government, in response to that, decided to appeal that ruling up to the Fifth Circuit. And now one of the big issues with this case is the Trump DOJ continues to make anti-Second Amendment arguments in this challenge and also in other challenges which deal with machine gun possession laws. In the federal government's recent brief, they argue that lower courts in these decisions involving machine guns, that they were a clear error and that they should be reversed. They argued that machine guns are not typically possessed by law-abiding citizens for lawful purposes. Instead, they are uniformly restricted, highly lethal, and well-suited for criminal purposes. Now, this really is just a standard anti-gun argument being made here by the Trump DOJ, which is sad to see that the Trump DOJ and AG Bondi in her office are still pushing these anti-gun arguments. They also argue that Bruin's analysis did not override what the Fifth Circuit said prior in that Hollis case. They claim that nothing in Bruin unequivocally overrules or overrides what the Fifth Circuit said prior in their precedent, and they claim that even though Bruin corrected the type of 2A analysis that should be performed in these cases, it did not directly address machine guns or that Fifth Circuit precedent in Hollis, and therefore it still stands as valid. Now, in this case, the plaintiff recently filed their brief arguing that the lower court got the analysis correct and that, at the very least, the Fifth Circuit should hear oral arguments in this case, despite the fact that the Trump administration is arguing that the Fifth Circuit should even just avoid this, that they shouldn't hear oral arguments, and instead they should just reverse and kick this case back down. But things just got a little bit more complicated in this challenge because recently the 10th Circuit ruled on the Morgan case, which again dealt with machine gun challenges. And in that ruling, the court there held that Morgan failed at the very first step of the Supreme Court's Bruin test of proving that machine guns he possessed were arms in common use today for lawful purposes like self-defense. The judges in the 10th Circuit emphasized that although handguns and other widely owned firearms are protected, machine guns such as the ones that were owned and possessed by Mr. Morgan, like a Glock switch, that they are not commonly used by law-abiding citizens for self-defense. They found that instead, history and precedent shows that these types of machine guns are overwhelmingly linked to unlawful uses. They believe that they are used too much in crimes, that they're not used for civilian defense, and therefore they do not have 2A protections. And the Trump DOJ recently just submitted that ruling out of the 10th Circuit in this Brown appeal to the 5th Circuit, saying that the 5th Circuit should essentially just follow exactly what the 10th Circuit said. So this case is moving forward still, and the administration is still arguing against machine gun possession, and they still argue that they are not protected arms under the Second Amendment. Even worse, they are arguing that the Fifth Circuit should just not hear this case at all. They should not hold oral arguments in this case, but instead just rule right here and now on the papers, rule based on what the 10th Circuit said in that other Morgan case, and reverse what the lower court said here in this Brown decision. So it's unfortunate to see that the Trump DOJ is still pushing these anti-Second Amendment arguments, these anti-gun arguments, and now they're trying to use a decision that they got in the 10th Circuit as additional support for why this 5th Circuit appeal should just be rejected, and this case should be reversed and sent back down, and that machine guns do not have any 2A protections at all. So now we're going to wait to see, what happens, but unfortunately, like I said, the Trump DOJ is still making these anti-gun arguments on this issue of machine gun possession. They're still making these arguments in these machine gun possession cases. So now we're going to have to wait and see how the 5th Circuit handles this. Are they going to simply align themselves with what the 10th Circuit said in that other Morgan case? Or are they going to at least hold oral arguments in this case, hear the plaintiff out, and consider and weigh these issues on their own? So this is a huge case, a huge decision, and a very important appeal in the 5th Circuit dealing with machine gun laws. So as we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, ARMEDSCHOLAR.com. Over there, we have a lot for you guys, coupon codes, deals, the free legal guide that you can sign up for. So a lot. So if you're interested, check that out. Go to ARMEDSCHOLAR.com. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.